Franklin Cudjoe is on the line. Franklin, good morning. Welcome to the program. Your preliminary thoughts on what we saw on Thursday in respect of the Supreme Court's decision, or on Wednesday, I think, in terms of the Supreme Court's decision on the Speaker's application.
Good morning to Lawyer Avan and Ahmad Ligba. Well, and yourself, by the way. Look, for me, I mean, as I said, I was watching did I say, a very grand movie, a nice movie. I was just waiting for that part of the Chief Justice's ruling. Well, should I call it a ruling? Or I don't even know whether it's a ruling or
it's a ruling.
Basically suggesting that some people had been disenfranchised, and because the actions of the Speaker and anybody who supports the Speaker was going to endanger, in fact, actually lead to disenfranchisement of these persons, thousands of constituents she mentions, then definitely something must be done. And I totally agree with her. In fact, I doffed out my hat for her and then the judiciary. But I couldn't help realize the doublespeak and the hypocrisy basically thrown at us. When I say us, I'm talking about South. The people of South that were dispatched, discarded, disappointed, and abused for 4 good years as we speak, right from the Supreme Court, from day one. Now these guys threw us out and said, go away. Just go, you see. Supreme Court dismissing South people. Go. Just go, you see. When we came, we knew that we'd actually be, in fact, whatever you're calling it, one ton, whatever you're calling it, that you knew that something is likely to happen. So something is likely to happen. So you are trying to affect that. This one here, by Philip Kadochi, we were giving raw deal by the Electoral Commission, a stinking letter written at the dawn of election, and then that was all. By that fiat, we were disenfranchised. This Supreme Court was not in a hurry to ensure that the flagrant abuse, the disrespect for the Constitution, all these persons who come from South were not, they didn't even consider it at all. In fact, Chikata was essentially insulted, including the Attorney General, making mockery of the whole process. It's as if we did not even matter. So I'm not surprised that they are conjoined in thoughts and in actions, that they could have the nerve to actually say that some people were being disenfranchised after their MPs who had been pampered. You know, these guys have been pampered so much that they lose an election and they decide that, what kind of nonsense really is that? That you go for an election in a party internal matter, it's not as if ballots were stolen or whatever it is. I want to address that matter before I go. And then you lose an election, some of them even came fit, all of a sudden, and we are no longer part of the party. What is this nonsense? And I think the NPP should be interested in that matter and deal with it. The NPP is no longer the party we all knew, we recognized during the days of Darocha, and even as late as Kufuor's time. It's so much indiscipline. Anyway, let me digress. So these guys have served their term almost to how many more days? Just about a few days to the elections, right? And their constituents have been well served. They've been giving water, they've been giving electricity. Look, I was asking ourselves, so you guys have done this to us. Just give us, so correct the road, 5-kilometer road. All my friends that I thought were in cahoots together, zero, they all went blind. And these guys had the nerve to come and tell me together, Avenya is my own friend, but I told him that, Charlie, you guys did not serve us well. So you hurriedly go and procure a very cheap process, and I call it cheap because it was given for cheap. When we were struggling, we were stranded, we were subsumed, we were discarded by the EC, the local government minister, the government itself, and the Supreme Court. They just discarded us like flies, right? So when I heard that part of the ruling that said, oh, you know, these people, I said, yes, this is exactly what the law says. 4 years, they've eaten now. We've not even eaten. Meanwhile, we pay taxes, we do everything. Then when I heard those words, I said, what? Is this a gangster system? That what kind of system is this? I call it judicial terrorism, aided by legal plunder. And so I was asking myself, what is going on here? What is going on? The parliament did not sit for a few days because some people's rights were abused. And when we came, my brother, just Google and then let your listeners see it. Google the headline: Supreme Court SAP discarded, dismissed. Just like flies. So that was my umbrage. I took umbrage. I said, what is this? What is this world coming to read? That I sat and be listening to this crazy stuff. So that was my problem. And I see when you do that, then the other matters tend to come into focus, and then people say you are biased. Because then the NDC, sorry, I don't think sorry is a stupid lawyer. I did law as part of land economy. I didn't really do law as a law standalone. But I'm not stupid to realize that some of the things sorry was saying were just barefaced common sense. Well, of course, the law says whatever. But you could discard the person and how am I supposed to trust you and believe that you have actually used the law to rule? When you are just looking at my face, I came to you. Chief Justice, she was part of those people who discarded us like flies. Sir, munko. Their facial expressions was as if we are at war. Hey, I had 2 elections, I say, FC Crawford, they were discarded. That didn't matter to them. Up to now, do you know what happened? When they discarded us to the High Court, the High Court spent 3.5 years, my brother, Novinye, 3 good years. We were going back and forth of hope. The Achikata was my lawyer. Every now we go, we file processes. So at the end of the route, this world, the life, though, balance. The judge said he has no jurisdiction to deal with the case. Can you imagine? So when I hear that processes were not abused in the process of securing this so-called ex parte, then I ask myself, wasn't the process really abused? When we were told to go to the High Court, because that's the way it should start, and the High Court now turns around and says that this is it. We have no jurisdiction. As you speak, we are actually filing an appeal to the Supreme Court. And I'm asking what's the point? These guys will rule against us anyway. So let's just forget it, And he says, no, we need to fight. There's a gangster system. We need to deal with it. I said, yeah, I understand all of that. But look, maybe you don't see, you see what we are doing to ourselves. We are even asking ourselves whether we are sane, whether we are normal. I'm asking, and this guy is doing this thing for pro bono, right? Now, Chikata is doing all of this for pro bono, and Jimanu, I remember the name, from this month's law of firm. And they are doing all of this pro bono. And I'm asking myself, what is this? What type of system is this? So those are my remarks. I don't trust them. I don't believe them. And I don't respect exactly what they were telling people in the country, really. Because for me, I'm a living example. We are living examples of this, what I call the gangster terrorism type of thinking. I mean, it's precocious terrorism, legal plunder, and indeed, quite frankly, annoying and undemocratic. Thank you.
I see. That's Franklin Cudjoe. Very strong words there. Obviously, because I mean, he's been on the short end, or he's been at the receiving end in another matter that he was involved in, the SAL case, which dealt with the representation of people in the SAL area. If you recall, in election 2020, the people in SAL didn't vote because of some issues, and they've been pursuing that matter. Last minute, the court told them they do not have jurisdiction on the matter, amongst other things. So he's juxtaposing that, against what the court has said in respect of the representation of the persons in the 4 constituencies of the MPs in question, and he thinks that the Supreme Court hasn't been consistent. That is, of course, there are some nuances to that we may want to come to later, but that's what it is. So let's return to the decision now. The issue about natural justice, Honorable Amaliba, the Speaker arguing that he was not given a hearing, ex parte, etc. The Supreme Court thought otherwise. What do you think about this?
Well, I don't know what the Supreme Court said at that point, but I could hear the Chief Justice talk about exceptional circumstances that might have warranted the grant of the application, and went to the extent of saying that even though the application was ex parte, what he gave them, that in terms of the order, was interlocutory. You notice that? And I thought that if a party does not ask for a relief, you have no business giving the party that relief. But I noticed that all that was preoccupying the mind of the Chief Justice or the court was trying to go beyond the parties and look at something that was happening in court, which is the Parliament, and trying to think that the Supreme Court has a duty to fix what is happening in Parliament. And so that was preoccupying the mind of the Chief Justice, and she voiced it out. She even voiced out that, how can we be in a country and Parliament is not sitting? You know? So you can see that the decisions, the rulings that she gave or the court gave was in consonance with her thinking. People came for 10 days. No, 10 days is not enough. Let me do it interlocutory so that we can fix what is happening in Parliament. And so when you do that, as she did, then people begin to be questioning what you are doing. The Supreme Court assumes the power of I can do what I want, or I can do what I feel is needed to be done. But you go for ex parte, you are given an interlocutory decision. So I agree with Thaddeus when he said that, look, this was a matter, because there was an intervening Monday. Parliament was not sitting. This was a matter you could have asked that it comes on notice so that the Speaker could also be, in court on that day. So
I think just to provide some meat to that, let me read portions of it. It talked about the Supreme Court allowed the ex parte because of what he called exceptional circumstances that occasioned that. So he said it is a very basic and primary principle of law that an order to stay execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. Give some cases. In the ruling of the Supreme Court on the 18th of October, the court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker declaring the forces vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? So that's why they made a case about the 4 constituencies spread around for 4 or so regions: Ashanti, Eastern, Central, Western, and talked about the fact that, by declaring that they are duly elected representatives as the people in Parliament had vacated their seats for acts that were interpreted within the light of 97(1)(g) by the Speaker was actually enforcing this interpretation against the hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. In their view, that was an exceptional circumstance. So he was also doing so at a time that, from the official records of Parliament, the official record presented by Parliament to the Supreme Court, the Speaker knew that a contrary interpretation, contrary to the interpretation he was seeking to enforce, was being placed on the same constitutional provision, and the Supreme Court's jurisdiction had been invoked to provide correct interpretation. So not only was it contrary to the interpretation he was trying to put on it or enforce, the Supreme Court's jurisdiction in respect of interpretation had been invoked, and the Speaker knew because he alluded to it. So the Supreme Court's view is that once he knew, he should have stayed his hand for the court to put the proper interpretation on it as the Constitution mandates before going ahead to do that. So the court felt that these constituted exceptional circumstances, for which reason it allowed the application to be ex parte, because the effect was immediate and the effect was going to wreak irreparable damage or harm on the persons, not just the 4, but hundreds and thousands of constituents. That's what the Constitution said. That's what the court said. That is why it made it ex parte, and not really a matter of natural justice. I mean,
so would all this overweigh the right to be heard? Because you are talking about MPs being removed from Parliament. And that's an exceptional circumstance.
But you know we allow ex parte applications. I mean, for limited period of time.
Limited, yes. Yeah. I've talked about both. I've talked about both. So let's even assume what the Supreme Court is saying is true. My question to them is, does that overweigh the right to be heard in court? Because these people, even if the Speaker's ruling was going to stand, it will just stand for a Friday. And then a Monday you come to court, you have still told them that, Mr. Speaker, stay your order. And so that intervening Monday, and you see, when we are also talking, sometimes you go to the Supreme Court to file processes, and you don't get a date. It will take you like the next day or two to get a date. But Afeni Ombake was able to speed up the process. He got a date. But you can see that the right to be heard is also critical. And so there was an intervening Monday. And that Monday, the Speaker could have been asked to come to court to deal with the matter. Nonetheless, your ruling would have still been that stay proceedings. So the issue of natural justice, as raised by Tadiosore, was breached. In my view, it was breached. Because the considerations, the things that the Supreme Court is talking, cannot overweigh the right to be heard. I don't think so. Because the MPs, do you know that most of those MPs, 4 of them, they don't even come to Parliament. They've stopped coming to Parliament. So it's not as if you were going to...
You know, Cynthia Morrison was in Parliament
I say
on the day.
I think most of them, most of them they don't come to Parliament again. And so it wasn't like there was a need.
Failure to come to Parliament.
No, I'm not saying that...
They don't mean they advocated yourself.
No, they've not advocated themselves. I'm just saying that it wasn't anything that was so urgent. Nobody was dying in Parliament for you to breach the rules of natural justice. For you to talk about...
Did you see the effect of how the minority quickly rise to that side?
No, but
did you see that one?
No,
but you
Alex,
saw... But you saw that Parliament was adjourned. And the confusion you are talking about was dealt with by Mr. Speaker. I don't see any consideration that will overweigh the right to vote. For instance, the MPs were not going to be deprived of their salary for that day. It's not as if because they were expelled, salary for that day was going to be stopped. So the intervening mandate...
But the ruling and the enforcement of the Speaker's ruling meant that they advocated their seats, and so their emoluments, the Supreme Court also said, their emoluments, etc., were to be stopped.
And I'm saying that we have an intervening mandate which the Supreme Court could have reversed, which they have reversed. I'm just talking about how do we fix the issue of
service,
the natural justice. All these things cannot overweigh the right to be heard because they were not going to be deprived of their salary for the month. Once you work beyond 50 on the 15th, you still get your salary. So there wasn't any agency, even with the issue of what did they say? What did they say? Special circumstance. There wasn't any special circumstance at all that warrant the denial of the right to be heard. That's my submission.
I see. You also made a point about, okay, any response to that? I'll go to the issue about the 10 days, or I could put that together as well. Okay. So the grant of orders beyond 10 days, you alluded to that you get what you ask for. The Supreme Court said that you did so, or the Speaker's lawyer or the Speaker, made the point about Order 25, Rule 1.8, etc., of the High Court Civil Procedure Rules, being oblivious of the Article 2.2 and 2.3 and 2.4 of the Constitution. I quote, the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. So yes, the order with the subsidiary legislation says that 10 days for ex parte. But the Constitution is saying that the Supreme Court, could do it more or less as it pleases. So that is what they took advantage of. They said that the Speaker's lawyers urges that because of Order 25, blah, 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 that enjoins High Courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. Now, separating the High Court from the Supreme Court. Now, so he said this is a submission that fails to appreciate the import of Article 2.2 and 3, which guide the Supreme Court when dealing with constitutional matters such as this one. So that is the Supreme Court's reasoning in respect of why it extended the 10 days asked for and made it interlocutory.
And does it say that the Supreme Court can do what it did without recourse to the nature of the application? That when the